everyone joining us today for this very special webinar entitled A Transnational Dialogue with Indigenous Legal Experts. My name is Tia Rose Peters, and on behalf of our partner co-sponsors, the National Aboriginal and Torres Strait Islander Women's Alliance, the Indigenous Lawyers Association Queensland, and the 7th Generation Fund for Indigenous Peoples, we begin by recognizing the Indigenous lands and territories where each of us are located today, to honor the ancestors of those lands, the generations that are here now, and to consider our words, our decisions, and our actions on those yet to come. Wherever you are today, whether you're watching from a remote community, or if you're rural, or if you're participating from a Native nation, or in an urban setting, we are all on Indigenous homelands, Native territories. The 7th Generation Fund for Indigenous Peoples, for which I serve as Chief Executive Officer, we're located on Wiyot traditional homelands. We are all thrilled to have an excellent set of presenters for today's dialogue. Each have expertise in Indigenous law and human rights. They are luminaries in the legal world. They're also luminaries as thought leaders, strategists, relatives, and advocates, working to assure Indigenous people's rights, empowerment, vitality, and futurity. Dr. Beverly Jacobs is Associate Dean of Law at the University of Windsor, north of the Medicine Line, what some know as Canada. Our Mohawk sister is an outstanding advocate, especially for Indigenous women. Among her many accomplishments include completing her PhD in Indigenous law, health, and research methodologies in 2018, helping to research and write Amnesty International's groundbreaking report, Stolen Sisters, on missing and murdered Aboriginal women in Canada, and serving 2 terms as the president of the Native Women's Association of Canada. Joshua Creamer, Barrister-at-Law, specializes in human rights class actions. He is a renowned advocate and has appeared in 2 landmark class actions, one known as the Palm Island case, Australia's largest racial discrimination case, and another, the case of stolen wages in Queensland, Australia's largest human rights case. Joshua, who's Waini and Kulkadoon, has achieved many well-deserved recognitions, including in 2017, when he was the recipient of the National Indigenous Legal Professional of the Year Award. This special dialogue is facilitated by the Honorable Deborah Sanchez, who is the first Native woman to serve as a Superior Court judge in Los Angeles, California, a role she has served for the past 13 years. Previously, she was an attorney for nearly 20 years, including work with the Los Angeles City Attorney's Office for more than 18 years, primarily prosecuting child sex crimes, child exploitation, and employer criminal negligence cases. It is my honor to introduce Evelina Tarago of the Queensland Bar Association. Thank you.
Thank you, Tia. I'd also like to acknowledge the traditional owners and land where I'm speaking from today in Meanjin, colonised as Brisbane in Australia, and pay my respects to the Yagara and Turrbal people here. I'd also like to thank our partners today in bringing forth these really important voices who we need to elevate. It's really important that we showcase our Indigenous legal experts that are around the world, and also because it is sometimes an isolating journey to break down and decolonise the systems that can be advanced for our people to move forward. As a consequence, we sometimes carry that trauma of our people when we're doing so. So it's really important to connect and collaborate with one another. And we're so fortunate to hear from 3 amazing speakers today who do just that. So thank you once again. I'd like to pass on to Judge Deborah Sanchez.
Welcome, friends and relatives. I'm glad that you're here, and also I'm very honored to be speaking with Dr. Beverly Jacobs and Joshua Creamer. I'm very, very amazed and impressed by all the work that they've done in these various locations, and I think that the transnational dialogue is something that will enlighten you, and also it's going to show you the connections of these countries and how they're related. So I would like to start with Beverly Jacobs, and if you could tell us a little bit about your participation in the document, No More Stolen Sisters, and give us an update on your work with missing and murdered Indigenous women. Thank you.
Sorry, I had to unmute myself. Scanos Wego, Giaso Gowenki say, Gangahaga Nyakawai, shout down. Greetings of peace. Thank you for being part of this important discussion. Well, in answering your question, Deb, I would say that it's been a really long journey in talking about the issues of missing and murdered Indigenous women and girls, because it's really been happening since colonization, that our women have been targeted for sex trade, violence, murder. And so in beginning to work with Amnesty International, it was a very conscious decision at that time. So I was already meeting with some families of missing and murdered Indigenous women in communities. And there was a lot of information that they were sharing that was really sad. You know, that they were the ones who were having to do all the work when their loved one either went missing or was found murdered, and, you know, it was unresolved. So they would be the ones putting up the posters. They would be the ones who were doing the searches. And they would be the ones to have to sit in the courtroom by themselves and listen to the horrific details of how the women were murdered. And that's got to be the most traumatizing experience to have to live through, to hear those ugly, gory details and the trauma that comes with that. And so in that journey, in that first meeting around the fire with some of those women, and meeting at that time was the former president of the Native Women's Association of Canada, and her name was Terry Brown. She too had a sister that was missing from the downtown east side in Vancouver, British Columbia. And part of the work was to initiate a campaign on missing and murdered Indigenous women and girls, and then at the same time meeting with Alex Neve from Amnesty International in Canada. And it became a really conscious decision to work with Amnesty International with respect to understanding the issue as a violation of human rights, and that as Indigenous women being targeted, not only because they're Indigenous women, but also because of their relationship to lands and territories, and the erasure of Indigenous women from not only their lands and territories, but that whole genocidal process of trying to erase us as a people. So who do you target first? You target women who carry our babies. So you attack the women and you have no more babies. And that was probably one of the most difficult, discussions and conversations and meeting with families while working with Amnesty, because they were sharing those traumas for the first time. No one had come to them before to say, what do you need? What can we do? How can we help you? And a lot of those families were willing to share their stories with me. And, I went to their homes and I went to their communities, and, and their families shared their trauma. They were horrific. And so it was not only emotionally emotional harm for them, but also the spiritual harm. When the spirits of those women, especially when they're gone missing and they have no idea where they're gone, they live it on a daily basis and wake up every day wondering where they are and what they're, whether they're safe. And it becomes years, waking up every day for years wondering where they are. And they've disappeared. No, there's no trace. And then their horrific relationship with police. That was probably the worst that I had heard in many of the stories of those women, that their families would end up being investigated. And they were told, over and over again that they were the ones searching, and they end up being violated by police this time and being questioned, and just the pain that they went through when nobody was listening. And then having to go through years of that trauma. And I ended up on one of the last places that I went to during working with Amnesty was at the downtown east side, where there was a serial killer who targeted sex trade workers from the downtown east side, and just he buried them in his property. And one of the messages, a lot of times, there were some responsibilities that I felt I had toward the spirits of those women. So I went right to the property and had ceremony with the elders there. And I remember that that feeling of a loss of hope at that time, and seeing the land being it was being scooped up because they were looking for their DNA in the earth. And I was just thinking about how, in our teachings and our knowledge about women and the earth and the relationship, and how these women were violently murdered. And even though they were brought back to the earth, just that horrific feeling of that loss and that trauma. And so many women who were part of that. And so in talking to those families and the elders from the downtown east side, and who were trying to bring attention to the issue even before I arrived, there was at least, by the time I arrived on the scene to do the research for Amnesty, they had already been trying to bring attention for 20 years, even before I came along. And so just the attention of it, and the lack of attention, right? And the voices that couldn't be heard, and it was devastating. And I did end up getting physically sick as I was leaving there, just because of all of that trauma. So it was not only that healing work that I needed to do, as well as as someone coming in who is an outsider into those communities, and respecting their knowledge and where they come from, and what they've had to go through, and then bringing it to the public, and having to even educate them about, well, who's Amnesty International? What are they going to do for me? What do they do? So it was an educational process for all of us. And so when Amnesty released its report in 2004, it was the first time on that international scale to recognize those the families who had that loss. And I would have to say, and working with all of those families, all of those years, they ended up being the leaders in the most recent inquiry for missing and murdered Indigenous women and girls. They became the family, they had a family committee that was part of the inquiry, and just seeing how powerful their voices were in such a public place, and supporting other families who did participate in that inquiry, and just seeing the strength that they've had, and some of them have become leaders in their community. So that's what I found also very empowering through this process, is the strength of our families, and the resilience of our families, and the women and the mothers to be able to survive such trauma and occurring. We know that it's not just occurring in Canada, it's occurring everywhere. So at a global, international level. And so I think, what's happening today is those families, and they're on the front lines again, and trying to bring attention to the issues. Even though we did have an inquiry here in Canada, it's still, there's been no response from government. There's been no response of the recommendations and the calls to action from any government, whether federal or provincial. So waiting again. And so there's a lot of people now, a lot of those advocates, and many of us who right from the get-go, wanting an inquiry and then getting an inquiry. And it was, the report itself was I was highly critical of it, because it didn't get to the root of the problem, which I felt was land, that you erase people from the land. Although they did recognize that genocide, that it was a genocidal process, that it is, that to me was really important as well from that report. So I wanted to share, that information, and there's still advocacy that's happening for the families, and the families are the advocates now. And that too is, not only they have the support in their communities now, which is different from the beginning, but the attention that they've been able to bring, not only to the media, but also to the public. It's not as high as it should be, but it's happening. And, it did grow at the grassroots level. And that's where I see things changing in the community, is also the support of those family members who are having to deal with it on a daily basis.
Let me ask you a question before I move over to Joshua Kramer. The Stolen Sisters report was from 2004, and then, as we all know, the Declaration on the Rights of Indigenous Peoples was adopted by most everybody except Canada, Australia, United States, and New Zealand in 2007. But since it's been adopted, and since that report, I know that, has anything changed in terms of the slow acknowledgement, I guess, of the public, maybe even of government, but has there been any progress, in a sense, as a result?
None. No, nothing. I mean, there's like complete silence. And in fact, I would say that the federal government it's not even an issue for them. They're not addressing it. They're not implementing it. They're not doing anything to recognize it. They say in different presentations, what I call manipulation of words, even at the UN, when Carolyn Bennett, who's the Minister of Indian Affairs, they can name it whatever they want, but it's called the Department of Indian Affairs, her presentation, and saying that they were actually planning on they recognize the declaration, but there's no implementation. It's just like treaties. Treaties in Canada, there's treaties, but they're not implemented, right? It's the same crap over again.
The disparity in how well, I've seen a lot of other materials about the lack of investigation, like you said, it's the families that were really involved in trying to find their loved ones. And then that disparity in not only whether or not there was investigation, but if investigation was done, it wasn't done. It wasn't sufficient. They didn't provide the resources that they needed in order to come to some kind of conclusion. And that's one of the things I recognize with the Palm Island case as well, because there was the police themselves who were the ones who inflicted, created the murder, and then the police department itself investigated itself. And then whether or not, I think some of the Aboriginal witnesses were ignored, and it reminds me of California laws and other laws, and maybe in all over the United States and probably elsewhere, where Indigenous people could not testify against a white perpetrator, whether it be rape or murder, or child stealing, and anything. There were actual laws on the book that prevented Native people from testifying against persons who had committed egregious crimes. And so I wanted to go over to Joshua Creamer and ask you some more about the Palm Island case, and if you can, our viewers would like to know more about the factual scenario as well. And thank you.
Thanks, Deborah. And I just wanted to acknowledge all our First People who are sitting all over the world watching this at the moment. It's the wonders of technology. So the Palm Island case, 2015, we went to trial, but I just want to set up some background. So in Australia, there's no recognition of First Nations people in the Constitution. There's no treaties, and there's certainly no National Bill of Rights or Charter of Rights, although some states have started to implement that in the last couple of years. So we had to, and that's significant because as a lawyer, whenever you want to start litigation, you need a power. You need a provision in a piece of legislation or a contract or a document that says you have certain rights and interests, and you need to be able to enforce those. And so we just don't have those here in Australia, the ones that you would ordinarily want to rely upon. But what we did with the class action, and I say we because all of these matters, I'm working with a big team. And I'm actually involved in about 6 class actions at the moment, which I'll talk to during today. But we relied on the Racial Discrimination Act, which was the implementation of ICERD in Australia, which dated 1975. So the International Convention on the Elimination of Racial Discrimination became part of our law effectively with the passing of that Racial Discrimination Act. And why that's so significant, I think, this case is so significant is because it's such a common story. So an Aboriginal man was in a small Aboriginal community of about 2,000 people here in Queensland, the state in which I live. About 10:30 a.m. November 2004, he was walking down the street, arrested a short time later by police, and he was dead in his cell about 45 minutes later. He died from basically the autopsy report, or the expert at the time said the injuries were similar to a car accident. So he had a ruptured spleen, a ruptured portal vein, 4 broken ribs, and a cut above one of his eyes. So after a week, there's initial investigation, and we had what's commonly known as the Royal Commission into Aboriginal Deaths in Custody here in Australia in 1991, and that laid out a lot of recommendations, really to reduce the risk of deaths in custody because it becomes such a significant issue. And I just will point out that it's really had no impact. But regardless, though, The death occurred in November 2004. The police then conducted an initial investigation as if it was a health incident, or not necessarily self-harm, but certainly not to the same standard you would expect of a murder investigation or a homicide investigation. So they went in and conducted a really poor investigation. About a week later, the autopsy report is read out in a community meeting. And a short time after that, there's civil unrest. So over the space of about 2 hours, the police station and the adjoining courthouse is burnt down. And then there's a standoff with police. And after a few hours, it sort of disseminates and there's nothing left. In response to the protests, police sent in for this community an enormous amount of police officers. So ordinarily, there'd be 7 police officers stationed on the island. 4 of those would be on duty at any one time, and they had a general practice where they wouldn't carry weapons because there was just minimal perceived threat in the community. In response to the protests, police flew in over about 100, I think it was up to 110 police officers, and about 30 of those were from our SWAT teams, so PSRT and CERT teams. And then over the next 36 to 48 hours, they conducted raids on homes, arresting about 18 homes all up. And the really type of brutal, everybody understands if you send in SWAT into your home at 5 a.m. With 6 officers going inside with assault rifles, balaclavas, all the equipment, and you've got 12 or so officers stationed outside the house, men, women, young children, grandparents, all of those in these homes. You imagine the type of distress that was caused by that incident. And just a lot of stupidity around how that was used. And I say stupidity because it purely was. There's one instance where they went looking for somebody. They raided 6 or 7 homes looking for this one man. He found out the police were looking for him and went and handed himself in that afternoon. Another male, he was sitting in the local council's office with police officers the day before, talking about what can we do as a community to try and address these issues. Within about 12 hours, his house was raided and similar type of circumstances. So what we did with that case, we said that the police actions was a breach of the Racial Discrimination Act in a number of ways. Firstly, the police investigation into Mr. Doomadgee's death, and the judge ultimately determined that the investigation lacked impartiality, wasn't independent, and certainly wasn't effective. So when you were talking to Beverly about the types of investigation, so we targeted the investigation and said, well, if it wasn't an Aboriginal community or it wasn't an Aboriginal death, then there would have been a better standard than what was executed. And we were successful on that. The second part that we were successful on was police have an overriding, in Queensland, they have an overriding responsibility to maintain peace and good order. So in the days after the death, instead of using their resources to try and diffuse any tension and any anger, which they were aware was building, they simply didn't. And one of the commanding officers actually informed some of the young police, look, go to bed with your guns because this is going to flare up. Just real inaction and again, stupidity by the police. The next area, and there were a couple of other areas, but the main other area which we were successful with the case, so breach of Racial Discrimination Act, was the response to the protests and the fires. So that sending in of the CERT teams and SWAT teams just was completely unnecessary in a community where there was simply no threat. What came out during the course of the trial was police, when the unrest was occurring, police had a rifle. It had no bullets, no ammunition, but they left the rifle in the police barracks. They then used the missing rifle as an excuse to conduct the 18-odd raids. What came out later was that the police rifle was in fact where they had left it. And not only that, but when police were making all these arrests, they were actually interviewing people in that barracks. So the weapon had never left the barracks and the threat was just a fictitious. And again, our argument was that that type of action would have never have happened but for it being an Aboriginal community. One of the, I'll just finish up here on this point, but what I think the overriding principle which we were able to establish with this case was that government, whether it's through the police as their agent or health or education or anywhere where there's interaction with Aboriginal people, government's role is to provide a service. And where that service is defected by virtue of our, because they're dealing with Aboriginal people, by virtue of our race, then that's a breach of the Racial Discrimination Act. And so we've then used that principle in one other case, which we settled, a $190 million settlement for stolen wages. But as I say, there's 6 other class actions that I'm currently working on, and we're using that principle, the provision of services by government and defects by virtue of race, as the basis of our case. And critically, one we've really just been working on for 2 years, but literally just started ready to file in court this month, is in relation to child removals. And every country, every Aboriginal country around the world would understand the rate of child removals is continuing to increase. And so this case will say that child removals in our state over the last 20 or 30 years have been a breach of the Racial Discrimination Act.
What's interesting, I think the viewers should note, is that when I was in Australia in 2014, there was a huge protest about the number of Aboriginal children being removed from homes and being placed in non-Aboriginal homes, foster homes. And in the United States in 1978, part of that, almost the same percentage, between 25 and 30% of the children that were being removed, created the Indian Child Welfare Act. And it's not perfect by any means, but it has a protocol to help place the children either with their families or extended Indigenous families, or people within their Indigenous communities or other Indigenous people. And one of the things that I noted was the percentage was almost exactly the same as before the Indian Child Welfare Act was enacted in 1978 here in the United States. One of the things that I noted when I was reading about the case, the Palm Island case, is that there was an attempt to prosecute the officer that killed the man that was in custody, and I think he was charged with manslaughter, and they acquitted him. Is that correct?
Yeah, so there was a real difficulty in prosecution, and my view is it was because, firstly, the investigation was so poor. So if a police officer is involved in an incident and the investigation is going to be of a poor quality, you're never ever going to get a conviction. And so that was, I think, the failing from the start. But secondly, the prosecutions in Queensland actually refused to prosecute initially. Became quite a significant issue, and the Premier in our state got involved and briefed, I think, a retired judge from another state to conduct a review of the prosecution. And then the prosecution was actually conducted by not the prosecutor's office. But yes, that's right. He was acquitted. So that was a long process even to getting that. But he was acquitted. And obviously, certainly when you understand the flaws in the evidence, there was an Aboriginal man who was sitting 4 metres away from what occurred, and his version was never accepted of the incident. But that prosecution itself then relied entirely on the evidence that was collected by those officers who ultimately found to be in breach of the Racial Discrimination Act. There was no other independent investigation which was relied upon in the prosecution. So in many ways it was doomed to fail from the start. But can I just say, that was the first time in Australia's history where there had actually been a prosecution police officer in relation to a death in custody.
And one of the other things I noted, and it's very indicative to some of the things that are happening in the United States now with Black Lives Matter and the killing of George Floyd and others, there's a long, long list, is that the that reluctance to prosecute, that's one thing. The level of how the officers are charged, that's another. That also, similar to what happened at Palm Island, just the sheer either failure to collect witness information or ignoring witnesses from the community. I also think that just the framework of the society, right? So everything's like on this foundation of this disparity between a white population versus indigenous population or aboriginal population. And that one of the things that I read about, there's I don't know if you ever heard of her, but her name is Jane Elliott. She's a white woman who helps people understand racism. And one of the things that she had this program, and she said, how many of you would like to be treated like a Black person in the United States, right? And no one stood up. She goes, I don't think you understood me. Why, if you believe that you would like to be treated like a Black person, stand up? And nobody did. And then she said, well, that tells me that you understand that there's a disparity in the treatment. And if you wouldn't subject yourself to be treated that way, why would you let anybody else be treated that way? And so what we're seeing too in the United States is this, there are people of all different walks of life now that are demanding accountability to recognize the urgency of this, of the brutality that's inflicted against a sizable population. And that's really unique about these particular times. And I think also that the pandemic had something to do with that, in the sense that people were able to pay attention, where not just running routinely through their lives and actually paying attention to what was happening in this country, not to mention some of the other things that have also gone on that have opened people's eyes. And also, I think I wanted to ask Bev about one of the things I was reading in the report is all of the law that had basically divested women of their identity, of their indigenous identity. One of the things it talks about, there was a law in 1857 that allowed indigenous men to renounce their indigenous status and live off the reserve in order to assimilate into non-indigenous societies. And women weren't given the same choice. The Stolen Sisters report was saying that it was really dependent on their father's choice or a husband's choice. And so a lot of those women were disenfranchised from their own communities, their own identities, and that oppression also that occurred systematically through these laws, they manifest themselves in today's situation with the missing and murdered women. And I wanted to know if you can comment a little bit about that.
Yeah, so we had called that as a root cause of missing and murdered, and the relationship to Canada being responsible because of the laws that they enacted, right? So there's a piece of legislation that still exists today called the Indian Act. And so in order to define an Indian, in 1850 was the first piece of legislation. You were a man who could be registered as an Indian. So it was a very patriarchal piece of legislation, very Eurocentric, based on Victorian rules. If you were a woman marrying an Indian, you became registered under his nation. So if you, for example, if I married at that time to a Mohawk woman marrying a Cree man, for example, I would have to move to his territory and I would be registered under his nation. So I would lose even connection to being home in my territory. So that's opposite to Haudenosaunee law, because our laws are based on women's relationship to the land and title to the land. So you flip that, and so even if a woman married a non-status Indian, I make that very specific, because if she married a non-status man, she lost her status as an Indian. She was no longer considered an Indian. And I say that because if she married a white man, obviously she would have no status. But as Haudenosaunee people, there's a border that goes through our territory, right? So if I pick on a community called Akwesasne, and the border goes right through their territory, if a Mohawk woman who lives on the Canadian side of the border marries a Mohawk man who lives on the American side of the border, she loses her status as an Indian. And so that caused like generational issues of, and also about identity, because it caused a lot of that, what I call, and what we have called like movement from our traditional territory, forced displacement. And so that is a real issue, especially for Indigenous women who were connected to their lands and their territories. And also, I think I had said earlier that was like the first phase of missing Indigenous women, because a lot of our women who married out, we lost them, right? So they weren't allowed to come home. They weren't allowed to even be buried with their family and their territory and their community. And I know that for a fact that the Canadian government would send the women letters saying you would be treated like every other white woman. So what did that mean? It meant they had no rights. So it was a real direct attack. That federal piece of racist, I call it the most racist and sexist piece of legislation that exists in the world. There's nothing like it anywhere, except in Canada, where it, they're defining who an Indian is, and based on a trip of Christopher Columbus to a place that he thought was India, right? So we were termed Indians, and that's not even right. So it's just a whole, in looking back at those root causes and what has caused all of this harm is directly traced to Canada and its laws and policies, and even illegal policies. They had illegal policies called the pass system. And the pass system was also, right, so the Indian Act created these reservations, so this reserve land and these borders, these little checkerboard or these little small pieces of land that ended up being called reservations. Having Indian agents in those communities that was controlled by the Department of Indian Affairs and by Canada. And they wouldn't allow anyone to leave the community without this little ticket, and they call it a pass. So they allowed them to controlled them leaving the community. They were given these little tickets saying, oh, you're allowed to leave the community for 2 days or an hour, or and so they managed that, and they would manage who would come in and out. And so if a woman they knew who had married out, they would literally say, you're not allowed to be here. You're not allowed to visit your family. You made the decision. So those were the kinds of real issues that had an impact on Indigenous women and their relationship to their lands and their territories. And so it's a real issue, because the Indian Act still exists here. It's still legislation that controls everyone who's a status Indian, including me. There's a term that was used, from the womb to the tomb, from the time that you're born, when they decide what how you're registered under the Indian Act, and even until you die, and even after you die, because the Minister of Indian Affairs controls my will, and that has to be approved by the Minister of Indian Affairs. So they have so much control, and that's part of the issues that we're dealing with now in our communities, and trying to deal with the generational. So there's been many generations. The Indian Act itself was also used as a tool to create the Indian Act, or the residential school system, right? So in Canada, with the residential school system, and the many generations of children who were forced into those systems, and now having to deal with the trauma and the intergenerational trauma to this day. I mean, that's where we trace everything right back, and that's was part of the research that was done in the Stolen Sisters report.
Now, I know that we have a question that it really reminds me too of what Joshua was talking about, and I wanted to ask him also about stolen wages. But what I want the viewers to know is that in every one of these countries, Canada, the United States, and Australia, all of them had laws that would allow for the taking of the children. There are residential schools in Canada, boarding schools in the United States, and the stolen generation in Australia. And when we were there in 2014, we had a chance to visit one of the boarding or residential schools there in Australia, at Schönberg. And it was just devastating to see. And that's when I started to look at the overall global picture about how the laws also and the practices in the United States also influenced and impacted Aboriginal people, Indigenous people in Canada and in Australia. But one of the things that is a consistent, I guess, a consistent way of dealing with our people has been to act as if we don't know what we're doing, that we are not able to manage ourselves, we can't manage our communities, we can't manage our lands, we can't manage our money, we can't manage our children, all of those over and over and over again. And that has been like the foundation of the devastation that has occurred in all of these countries for their Indigenous people. But before we go back to Joshua, I wanted to see, Tia, was there a question?
Yes, thank you, Deborah. There's a question actually that goes right to that very point that you're making. It's from Eva, and I'll read it. It says, we looked at the Indian Child Welfare Act, and then based on that, designed the Aboriginal and Torres Strait Islander child placement principle. Despite it being in place for decades, our numbers of children being removed from family and community is ever growing. It would be good to hear from Deborah how the Indian Child Welfare Act is being implemented successfully and changing the trend so that we can learn from it. Thank you, Eva, for your question. Deb?
Yeah. Well, in the Indian Child Welfare Act gives certain preferences. It's a federal overlay, though. It's a federal act, but part of the issue has been that each of the states follow their own laws. So the states follow their laws when it comes to the children, and then there's a federal law that overlays that process. And so some of the I guess some of the benefits have been that there's a placement preference. So you either go with your extended family members, your Indigenous family members, if you're identified, and that's another issue, right? To identify the children as Indian children or Native children. And then if it's not the close family members, then it would be extended family members, Indigenous family members, or tribal family, tribal people, other tribal people that that are able to foster or care for the child. But in addition, there's also other Native people. So other Native people, and they were allowed also to get preference in the placement of the children. So there has been some strides, but there's a lot of problems as well. And there was a case not long ago where, I think it was 2013, it's commonly called the Baby Veronica case. And in that case, the father was in the military and they were in Oklahoma. The mother removed the child from Oklahoma after they broke up. He must have known that the child was born, but he didn't know that she removed the child to South Carolina. Now, South Carolina had their own laws that that were really detrimental in this situation. So eventually, the South Carolina Supreme Court said the Indian Child Welfare Act applies. And after the father hadn't seen his child for 27 months, they turned the child over to the Indigenous father, who was a Cherokee man. Well, after that, it went to the Supreme Court, and the Supreme Court, in a I think it was a 6-3 decision, no, 5-4 decision that said that no, the Indian Child Welfare Act didn't apply. And a couple of comments that they made were about the blood quantum of the child. So even though that's not even a consideration, that the tribes get to decide who are their members. So different tribes have different criteria, right? So even though that wasn't part of it, they mentioned it. And it was the 3 women on the US Supreme Court and Justice Scalia, the late Justice Scalia, who decided were in dissent. And so there's a lot of problems, because even in that case, the mother of the child did not give the correct name, spelling, or the birth date of the father. And they said they couldn't confirm whether or not he was a Cherokee citizen, or whether or not he was eligible, or whether the child was eligible for Cherokee citizenship, which he was. So there's a lot of issues with that, but I do think that having a preferential placement, it's a tool, but the overall structure, colonial structure, and the laws that have been implemented, we're at such a disadvantage, because it's the worldview part of it, and also we're at a big disadvantage because it's not taking into account a lot of other factors. So there's black or white, and one of the things that Joshua mentioned is, like, you have to have a law in order to something to hinge on the disparity on, or to show that there's an injustice that's occurred, in order to, well, but there's a lot of other things that are in the gray area. Then if you don't have that, you're not able to pursue it in court, and that really leaves us in a situation that's it's untenable, right? So, but I thank you for the question. And I also wanted to ask Joshua about the stolen wages class action, because once again, it's a situation, my understanding, a situation where Aboriginal people earn money, but it was kept like in a trust. And also the disparity in terms of the amount of wages they were underpaid and as well. So Joshua, would you mind telling us a little bit about that class action?
Yeah, happy to, Deborah. I just want to say a couple of points on that Aboriginal child placement principle. We're using that as part of our case that we're about to launch this class action in Queensland, the state in which I reside. And it's going to involve thousands and thousands of group members. But the state, that's in legislation and failing to adhere to that. And what is also in legislation is that there's a requirement that Aboriginal children maintain a connection to their culture, depending what group that is. And none of those things are being followed. So that's going to become a really significant case, hopefully. The class action involving stolen wages really touches on those points that Beverly said. We had legislation here across every state in Australia which controlled Aboriginal and Torres Strait Islander people. So in the mid-1860s, 1867, I think we had the first legislation in Queensland, which was the Industrial and Reformatory Schools Act. So that gave the government power to remove any child who was deemed neglected. And the legislation said that every Aboriginal person, or every Aboriginal child, regardless of the conditions in which they live, etc., is automatically deemed neglected. So that was the start of legislation. And then 1897 was the first of what we call the Protection Acts. So about 200,000 Aboriginal people resided in Queensland at the time of British arrival. And that was obviously 1788. By about 1850, they'd been killed down to about 25,000. And the Protection Act came in, and basically that then removed everybody into missions. So everybody in Queensland was moved to one of about 20 or 30 missions across the state. And they were there for the next 100 years. So the legislation only finally came down in the early, I think it was the mid-80s, 1986. So almost 100 years of control under this regime. That legislation gave the state, again, power to remove children. And even when there were families living in missions, children would be placed in dormitories, and access with their family was completely prohibited. And there'd be really significant sanctions, really brutal sanctions for children or family who wanting to interact. And I mean, the disadvantage we're suffering today, in my view, and I agree with what Beverly says, is a direct result of that legislation. And this is the reason why. In Queensland, you ordinarily won't be able, if you're under that legislation as an Aboriginal person, which everybody was, you were not allowed to be educated beyond grade 4. There were some exceptions going to grade 6. But that type of education wasn't comparable to non-Indigenous education. It was sometimes they were just singing church songs for 3 or 4 years. It was church hymns. So you weren't allowed to be educated beyond grade 4. By the time you turned between the ages of 12 or 15, depending if you're a male or female, what the conditions were, you were then sent out to work. Predominantly women, young girls were sent into white homes all over the state. So anybody could write in and say, look, I need a young Aboriginal girl to come and work as a domestic and do my cooking and cleaning. And they were automatically sent. So much brutality in that. The amount of rapes and abuse and just absolute brutality in those circumstances. And you would see, I've read documents of people who could only describe as absolute predators writing in and asking for 11 and 12-year-old girls, and would be sent those 11 and 12-year-old girls. And you can imagine the conditions. So they were sent out to work from about the age of 12. Men worked on the cattle stations predominantly. So all over Australia, we've got this whole idea of the white farmer built our nation, but it was really black labour. So they mustered the cattle, they built the fencing, they lived out in the stock camps for months on end. And again, their women were in homes. And there's a really famous instance here in the Northern Territory. It's called Wave Hill, an Aboriginal community. They were on a station. They walked off wanting land rights and other things. But when you read the story, one of the things that would happen is all the Aboriginal men would go out mustering during the day. They'd sleep out under the stars in the middle of nowhere. and any of their white supervisors who were there would take their vehicles and drive back and rape all the black women whilst those men were out mustering. So we have the trauma, which Beverly talks about. Then we have the educational disadvantage because we weren't allowed to go beyond grade 4 or grade 6. And then when people did start working, the legislation required that their employers were not able to pay them directly, but in fact had to pay those wages to the state. And the state would retain those wages. And actually, when you look at the documents and you see where it was spent, our roads in this state, our hospitals, all of our infrastructure, some of our really significant buildings today were built using those monies, and they just didn't go to the people who earned it. And critically too, in their community, so not only was it wages, but any property. So we've had some people who were great athletes, boxers and other things, any of their prize money, homes, anything they inherited, all went into trust to the state. So you ultimately get through this period, 1980, you have people who are poorly educated, and you have people who are impecunious. In some states where we're working, so Western Australia, which on the other side of the coast from where I am, other side of the country, sorry, people were never taught English. So they're illiterate, they're enumerate, they never went to school, and the people who owned the cattle stations were just able to use that labour freely. And what really I was thinking about recently is it's very different to slavery. Some way there's slavery, but in the other way it's not, because there was no value in Aboriginal people. You know, in some of the slavery instances, slaves would be traded and be brought, and there was a value attached to them. In Aboriginal people in this country, that were just, they could be sent and moved anywhere, and there was no cost. I mean, there's lots of stories where Aboriginal people working out on stations were killed, particularly in those early days, because there was just no value attached to their life. And so our case here in Queensland, and we have just started a Western Australia case and a Northern Territory stolen wages case as well, because this happened all over our states. It was to recoup or some compensation for that loss, for those monies that were stolen. In 2000, I think it was 2002, the government implemented a reparation scheme. So they didn't acknowledge that wages were kept, and this wasn't paid as compensation, but really just as a means to say sorry, I guess. They paid legislation. They paid about $2,000 each as compensation for some people. And you can imagine people worked for 20 or 30 years under this regime and had nothing to show. In our case, we were looking at recouping the money that was retained, but critically, and this is the racial discrimination component, we said that the way the reparation scheme was run was a breach of the Racial Discrimination Act, because government would say to people, look, we're going to pay you a $2,000 flat sum, but in order to do that, you have to sign a deed which will indemnify us and protect the state from any further litigation. And so we said, and in the absence of really proper legal advice, and people who are absolutely desperate for any money, given their conditions, given the legislation. And so we said that the way that reparation scheme was, again, a breach of the Racial Discrimination Act. With the Palm Island case, we went to trial and were successful. With the stolen wages in Queensland, we settled prior to the trial. So that settled, I think, end of last year. And again, the other states were only just in the early stages of those.
Thank you for telling us about that. I was thinking about, I know that there's a question, but I was looking at how, when I was reading about the case, they were talking about how incredibly rare it is to have success on a class action to this magnitude. And so I was very, very grateful for that work that you did. I know that my understanding is that Sandra had a question. Sandra, can you put your video on as well? And then there's a couple of questions for you,
Yeah,
Barbara.
I just had a question for Joshua. Somebody wanted to know what are the other class actions that he's running? Thank you.
Yeah, so I'm not running, I'm involved with a number of teams, but one of those, obviously, Stolen Wages, Northern Territory, WA, the DOCs, so the child removals in Queensland, breach of the Racial Discrimination Act. I'm also dealing with one in the Northern Territory, so here, which really about the living conditions that people were under. And then one we're doing in New South Wales, which is another state, which is, it's quite interesting, but it's the impact of PFAS, so chemicals that get into the water and the land, and its impact on the cultural rights of Aboriginal people in a particular area. So we've had some PFAS class actions here in Australia, which have looked at usually old Defence Force bases where they use this chemical in firefighting foam. But this will, and there's been a couple of settlements of those cases. But this will be the first one where the land is recognised as a community belonging to Aboriginal people. So it's a mixture of different human rights, but human rights and economic rights, I think, are really the future of class actions in Australia.
I'm hoping that maybe we can have a dialogue some other time also that focuses on the environment and environmental justice regarding Indigenous communities. There is a question also for Beverly and Tia. Would you like to tell Bev what the question is?
Thank you, Deb. Bev, the resources extracted from our traditional territories, treaty territories, is put in a trust. Is this trust used to administer Indigenous affairs? Does it pay for education and our own imprisonment and keep us tied to the paternalistic legislation?
Yeah, that's a really good question, and I was thinking about it as well when Joshua was speaking about the trust there in Australia. There is no trust anymore. When Maggie was asking the questions about resources extracted from our traditional territories, as Indigenous people, we don't ever see those resources that come from any development in any communities. Where I come from here at Six Nations, we've been in a legal battle with Canada for many years about the Haldeman Tract here, and this is what's happening in our territory as our young people are reclaiming land and situating themselves on developers' lands, because it's a land claims process. It has never been resolved for these hundreds of years. And just going back to that relationship when we had the Haldeman Tract, and there were leased lands. So leased lands to towns, to farmers, to individuals who leased it. So they rented. And it was an agreement with Canada that they take care of the money. So they became a trustee. Right. And so we never saw the money. We never saw the resources. We never saw anything that came back to our territory. So back to our communities. So there was a lawsuit requesting Canada to provide an accounting of those trust monies, and they can never produce it. So that's the underlying issue in our lands and our territories with respect to the reclamation of those lands and territories, because they owe rent. They owe rent from 100 years back. And so we're waiting for them to respond. We're waiting for them to provide an answer, because we all know as lawyers, when you're a trustee and you're holding clients' money, if you steal that money and you start buying property with it, you start using it for other means, that's theft, right? So Canada is a thief. and they've stolen that money from us for, you know, the last 100 years. And so that's part of the issues that we're dealing with now as we speak on the land here. So thanks, Maggie, for your question.
Yes, there also there's a question, another question for Joshua, but there was also an inquiry as to where they can get the Stolen Sisters report. I happened to look up. I looked at Beverly, and then in there was a link to the Stolen Sisters report, and I think it might even be on Wikipedia as a reference. But do you know how, or Bev, can you tell us better than my little research journey, where to get the Stolen Sisters report?
You can actually just Google Amnesty International Canada and the Stolen Sisters report. So there was one Stolen Sisters in 2004, and then I think it was 2009. There was another follow-up called No More Stolen Sisters. So so if you Google both of those, you'll be able to find it.
And one other thing is I also found some recommendations from 2020. So when it was updated from the 2009 No More Stolen Sisters, so you can find that as well. And then
yeah, and you can also find the Missing and Murdered Indigenous Women's Inquiry Report. Also details the history as well, and the genocide. There's like 4 volumes, I think, and one of them is on genocide. So that's a good one.
Thank you. And Tia, there's also another question for Josh, for Joshua.
Yes, thanks, Deb. This question says, will Australian governments, state and national, need to be forced to reform every step of the way through these class actions and litigation? Could Australia's new temporary national cabinet play a role for achieving reform across jurisdictions?
Look, I think they will be forced through litigation. And one of the reasons why is recently in Australia, we've announced what we call these closing the gap measures. And they've been around now for about 10 years, but there's a new version that's come out. And really for me, that's just that's a contemporary example of really embedding disadvantage in Aboriginal communities. And one of the examples I always refer to, and I've been able to refer to the last 10 years, is that education model. So the Close the Gap measure, and this applies across the whole of the country, is around ensuring that there's some parity between non-Indigenous and Indigenous children in relation to completion of their grade 12 certificate, so their high school certificate. And what government do is they actually, my view is the goal for every person, particularly Indigenous, should be on to university or some higher form of education. And in order to do that, you have to complete a number of subjects at university, at high school, to be able to qualify for university. But what you see with Closing the Gap is they actually they create financial incentives for schools and non-government organisations to push Indigenous children away from university. I know, I've sat on a few of these boards, I've seen it. So you get to grade 10 as an Indigenous person, you're automatically put into what we call like a secondary certificate, a certificate 2 or 3, in whether that might be business administration or hospitality or some other area, sports science. And the reason is for that is because the schools push you in because they actually get an increase of funding. If you start the certificate, they'll get a 50% increase of funding than they would have had otherwise. And the NGOs actually then will get an increase, I think it's another, double the funding they would have got otherwise as well, is if you complete the certificate and then you go on and you go into a low-skilled job. And one of the conversations I had recently with a big NGO here in Queensland was we have what's called the training colleges, so TAFE, which is, and universities on a completely higher level. But part of their contracts with government is they were forcing 80% of their Indigenous participants into TAFE. So what we do, what we're really good here in Australia is we're good at creating this myth or this perception that we're actually doing some good things for Aboriginal people. But really what we are is we're just embedding that disadvantage. So any Indigenous children who goes through that program and isn't eligible for university or some higher form of education is going to be impacted. We all understand that. But the system is actually targeted that way to create that. So, you know, for example, some schools here, as soon as you're in grade 10, if you're Aboriginal, you are not allowed to go on and do subjects that will make you eligible for university. So my view is, yes, we have to continue to force change through this, because the only way I think governments will change is if we keep hitting them with these really large financial penalties effectively, and they'll realise you can't keep acting the same way because you know, it's just not financially sustainable to do it.
Thank you,
Thanks.
Joshua. I'm just I'm of that same belief with the class actions, because it has an financial impact on the government, but also has some reparations for the people involved. It instead of in each individual case, and there's a lot of power in looking at the practices of the government and how they have dealt with Aboriginal people, Indigenous people. So I think that that's very telling as well. We're getting ready to close, to wind down. And so what I wanted to ask each of you, and I'll start with you, Bev, is for some closing thoughts, maybe what your hope would be for the future. And even our listeners, how can they help, or how can they be involved, or what can they do as well?
Yeah, those are really good closing questions. It always feels like being in battle, like being in a war all the time. That's how it feels all the time. We're, as Indigenous people, we're consistently in a war against Canada and its provinces. And so, you know, as for me as an Indigenous Mohawk woman, that's where I maintain my strength in my home and my community and ceremony, and you know, staying with my people. That's how I've been able to maintain my my strength and belief in our ancestors and their teachings, and that they're with us all the time to help us through these continuous battles. But I also really believe that that we're winning, that we are such a resilient people. We've been able to survive over 500 years of genocide, you know, and trying to erase us as a people. They haven't been successful. They haven't been successful because of the strength that we have to maintain our identity and where we come from. And once you are in that kind of space and understanding, you know, everything that's happened to your people, and then coming, you know, becoming educated in that colonial institution, and now being able to educate those who were not being educated before. And so education to me is huge, not only about our history as Indigenous people and our relationship to our lands and territories, but also the history of colonization and what's happened to our people, and how everybody is responsible, not just Indigenous people, but all peoples are responsible for the future. And so we've been, and I think when you talked earlier, Deb, about having future meetings or webinars about environmental justice, because that's everything about our relationship to Mother Earth and our responsibilities. And that's where I say we've been successful to maintain that as Indigenous people, that we've maintained that relationship with our mother, and fighting for the future generations. And so that's where my recommendation for those who are wondering how they can help. That's why I say, well, become educated, understand. And I always say your first education is the land. Whose traditional territory do you live on? And if you don't know that, then that's your first task, is to find out whose traditional territory you're on, who's your neighbors, your Indigenous neighbors, and trying to figure out and educate yourself about your relationship to that land, and how privileged you are to be able to live on that land. So that's my recommendation. So thank you. Yeah.
Thank you, Beverly. And Joshua, do you have some final words for us also, and maybe what you think the future will hold, and how we can maybe participate in the support of your work?
Look, I think really the solution is it's about power. It's about influence. One of the things that really interested me here in Australia recently with the Black Lives Matters was just how effectively our governments killed that whole discourse in Australia. Really quickly, they were able to deflect from that key issue, and they started talking about, well, protesters shouldn't go out under these health conditions of coronavirus, and I understand that, but and then they just basically killed that issue. I'm really surprised just to watch that, and how effective every politician in Australia was at killing any momentum we had. And we had a really large march here in Brisbane where I live. But so within a few weeks, that issue was just irrelevant. And I never heard one politician actually speak the words of deaths in custody, or mention any of the Aboriginal people that had died in custody. So, look, I think I totally agree with Beverly. I do think it's about education. I think we need more black lawyers and more black barristers with independence. There's only 12 Aboriginal barristers in the whole country in Australia, and that's out of about 6,000. In my state, I think there's about 12 or 13,000 solicitors, so lawyers more broadly, and only about 100 of those are Indigenous. And so I think we need to get educated, but we need to be in positions where we can actually influence change. And whether that's the class action work I do, or whether that's something else, I don't really believe that if you're Indigenous and you're working in government, you're going to make any significant change, because it's just such a big beast to be able to try and handle. But I do think that you can be independent, you can be in an organisation or somewhere else where you can actually impact on what's occurring. And people who want to support, I just think, don't accept the status quo, don't accept the rhetoric that you hear. Take the time to educate yourself. There's so many leaders out there in the communities and across the globe. Educate yourselves on these issues, and join with the movement, join with people who are making a difference.
Thank you, Joshua. Before I turn it over to Avelina, I just want to say that I'm also with Bev and Joshua on the education issue. Part of what I've experienced is that even in teaching American Indians and the law at the university, is the general student population, they have no idea. They have no idea what has happened in this country. They say that it's a great class, but it's sure depressing, because every week I tell them something new, and every week they say, gee, I can't believe that this happened. And so even educating our own brothers and sisters about the truth of how this country was founded, like for example, in the United States, but also I think that educating ourselves in general and looking at this global, I guess the global consequences of what's happened with the doctrine of discovery. and especially with the 4 countries that voted against the Declaration on the Rights of Indigenous People, which is Canada, the United States, Australia, and New Zealand. So if you look at that and you see the similarities in all these countries, they all started off as British Crown colonies, and they all have small remnant populations of their indigenous. And that's by design. The laws, for example, that I talked about earlier about not being able to be a witness in a case, whether it be murder, rape, or child stealing. They're the laws that allowed the government to take the kids in all these countries. That's what happened. And also not speaking your language, not wearing your clothes, not wearing your traditional clothes, not going to ceremony. There was a complete misunderstanding also, and whether or not they cared, I don't know, but the thing is about ourselves, do something to move your people forward as well. If you don't speak your language, start to use it, right? Find ways that you can revitalize things that, because we don't have to think like everybody else. And I think that that's important to know. And that's, they always talk about, sometimes even in my court, it's different. And I don't know what other people are doing. I've been in front of plenty of judges, but what I mean is that you bring your medicine wherever you go. You bring your medicine, you bring your worldview. And so no matter what you're doing, and whether you're a professor or a barrister or a lawyer, or you're working in in a grocery store, the thing is, we all have something to share. And how you treat other people, that love, respect, be honorable, I think it's critical. It's important, because it's not just what you do, but it's how you are that really can have a lasting effect on people around you, in your own community and in the greater community too, because we're all in this together. Like Beverly was saying too, is that we're all responsible for what's happening to our mother. And these are discussions that I hope we can have in the future. So I want to thank everybody, and I'm going to turn it over to Avelina. Thank you, Beverly Jacobs. Thank you, Joshua Creamer. Thank you, all of the viewers as well, because it's very important that we're together and that we understand what we're really facing. Thank you. Avelina?
Thank you, Deborah. I'll just check in with Anisandra if you'd also like to say some words before I do a closing.
Yes, I'd just like to say thanks for everybody who came on and listened to this, also to Seventh Generation, as well as to your organisation, the Indigenous Lawyers Association. It's really good to be a collective and to be able to speak worldwide about these issues. It's really important that we spread the message, and also people to learn the right information about what is actually happening in the courts and how our Indigenous lawyers around the world are running these cases. And it's good to give them a voice as well. Thank you all very much.
Thanks, Anisandra. So I again would like to echo the thanks to everyone who's joined us from around the world. It's fantastic to elevate these really important voices once again. I'd like to thank our amazing speakers who have generously given their time and shared their wisdom and experiences with us. So thank you, Dr. Beverly Jacobs, Joshua Creamer, and the Honourable Deborah Sanchez. I know for myself, I'm strengthened by the paths that you have created. And I'd like to thank Seventh Generation Fund for Indigenous Peoples and the National Aboriginal and Torres Strait Islander Women's Alliance in conjunction with the Indigenous Lawyers Association of Queensland. So thanks.
Thanks, everybody. Signing off.
Thank you. Yala.